The next piece that we're going to need to go through with the judicial branch is, as we can see in the stream for today, the PowerPoint and the notes. And again, it's not an assignment. It's not something that I'm going to be collecting, but if you have this done and complete, it's definitely going to benefit you in the next class period or so, if in case you need to use these PowerPoint notes. So it's fill in the blank, it's as you go, kind of on you, on the honor system, whether you want to follow along or not. And as I said, you can find this in the classwork. It's under the judicial branch PowerPoint and notes. So I'm going to go ahead and go through the PowerPoint right on here. If you just want to get the notes sheet out in front of you. So here's what the notes sheet should look like. If you want to get that out and follow along with it and type your stuff in or whatever and share a screen, split screen, whatever you got to do, by all means, go ahead and do that. I'm going to go ahead and go through the notes, or excuse me, the PowerPoint. I'll have it up on my screen here. You can follow along that way as well, but make sure you get things filled in. Again, this video is going to be up here posted for you. So if you need to go back and look at some things or stop me along the way so you can fill stuff in, go ahead and do so. So I'm not going to take too long to go through this. I'm going to get going at a decent pace. Again, if you need to stop it though, to keep up, by all means do so you can work at your own pace. All right, so the judicial branch here. We just watched those videos with Hip Hughes and Craig. And now we'll go through this PowerPoint. Whoops, it's not necessarily, that's okay though. We can go through this way. All good. So the judicial branch is what we're looking at here. The Constitution and the national judiciary. So what does it say there? Article 3, obviously, as we just learned about, of the Constitution establishes a Supreme Court. Gosh, I don't like this. I want to see this. I like it in a different view. Let's do this. That's what we want. Much better. Okay, so Article 3, sorry about that. It establishes a Supreme Court, and these are the words right from the Constitution, a Supreme Court in which the judicial power of the United States is vested. So it talks about that Supreme Court. It also mentions in there life tenure or good behavior for judges. So any judges that are appointed to federal courts, they have life tenure. They don't need to run for re-election. Once they're nominated and then confirmed for their jobs, they get to stay in that job until they retire or until they die. Judges receive compensation, so they get paid, and that pay cannot be diminished or lowered during their service. Such inferior courts as Congress may choose to establish. So when we talk about checks and balances, one of the checks that Congress is given here, our legislative branch, is over the judicial branch, and the fact that when it says such inferior courts, so like lower level courts under the Supreme Court, Congress gets to establish those. Congress gets to pick how many of those there are across the country. The only court that is established by Article 3 in the Constitution is the Supreme Court, where it says we have a Supreme Court. All the other courts listed below, or that come about below, are decided on by Congress. So Congress has some power over the judicial branch. The intent of Article 3 was to remedy or fix the failings of the Articles of Confederation, which left judicial matters to the states. Here we wanted to have some sort of federal judiciary or federal court system. The Articles of Confederation didn't have that. We just listened to Craig on the previous video from Crash Course talk about judicial review. And remember, judicial review is simply the power of a court to decide if a law or another legal issue disregards the Constitution, or what we would call unconstitutional. And again, so they can say, no, that's unconstitutional. So if Congress passed a law, for instance, that said people in the United States, like if you're in the United States, you can't maybe anywhere own a pistol, like a gun, a pistol. People are going to get mad, right? And they're going to say, wait, that violates the Second Amendment, the right to bear arms. And so if that made its way to the Supreme Court and was challenged in the court system, the judges on the Supreme Court have the ability to say, hey, you know what? Correct. That law violated the Constitution. It's unconstitutional. So they could strike down that law and say, no, Congress, you can't do that because it's unconstitutional. That's judicial review. Again, this power is not mentioned in the Constitution. They basically gave themselves that power in that court case that we just watched Craig talk about with Marbury versus Madison. And we'll get into that maybe a little more if we have some time next class period. The Marbury case, its long-term effect has been to allow the court to have the final say in what the Constitution actually says. So the job, okay, remember the one main job of Congress, the legislative branch, is to create and make laws. The job of the executive branch, even though it's got all sorts of different things to do, the main job is to enforce the laws, to make sure the laws are being followed. The main job of the judicial branch is to interpret the laws, to tell us what they mean, or whether laws are following the Constitution. So the American legal system is a dual system. We've got our federal courts. We've also got the state courts. So there are actually 50 smaller court systems within our country. Each state has its own state court system. So we've got a state court system here in Michigan. We have a Michigan Supreme Court, and we've got lower level courts underneath that. But then we've also got this big kind of overarching federal court system as well. Both systems have 3 tiers of courts. At the very lower level, we have what we call trial courts or district courts. This is where litigation begins. So if you ever heard the word litigation, like that's like the legal process. And they hear the facts of a case, like the original case, usually. That's where court cases start. They go to a district court. In terms of our state court system, there's a district court over in Holland. They're very local. They're smaller courts. And in those court cases, there's usually a judge, one judge that sits up front. That's where witnesses come up and testify. The lawyers for each side of the court case present evidence. There's always a jury or a judge then who decides on that court case. We say there's original jurisdiction there because that's where the court case originally gets argued. So within a certain boundary, any illegal thing that happens that goes to court goes to that specific district court. So around here, like I said, there's a district court in Holland. So if you were to commit a crime here in Zeeland, that's where your court case would be heard. Now, if you're found guilty or you're found innocent, maybe, if someone wants to appeal that decision, they can. They write an appeal, and then it might work its way up to the appeals court, or what we call the circuit court. So that's like the next level up. There aren't as many of those, so those cover a larger area. So instead of maybe cover the district court covering the greater Holland area, well, now maybe the next court up, the appeals court, the circuit court, covers like the greater Grand Rapids area. So anything that is appealed within that whole area, any of those smaller district courts, gets appealed to then that court. This is where they decide the questions of the law, not the fact. They review the decision of the lower court. And here at a appeals court, there are going to be, for each court case, 3 to 9 judges working together, or at least working on the same court case. There aren't witnesses, there's no new evidence. They just review what happened at the trial court or at the district court. Oh shoot, you can't see the bottom there. But at the bottom, there's the Supreme Court. And that's the top court. Okay, so if something is appealed then from the appeals court, a decision, and it may work its way up to the Supreme Court, which there's one. So at the very top, we got the Supreme Court. It's like a triangle. At the top, we got the Supreme Court. There's one up here. Then we move down to those appeals courts. There aren't quite as many. And then at the very bottom, we've got a whole bunch more trial courts. In our federal court system, our country is broken up into those circuit courts. So if you were in a federal court system, if you committed a federal crime, you would start at the lowest level. The closest federal court in terms of district courts, it would be in Grand Rapids. You'd go there, you'd have your court case. If that court case got appealed, you'd then go to the circuit court, the US Circuit Court. If you notice on this map, Michigan falls in this 6th circuit. The country is divided up into different circuits based on land and population. Okay, that circuit court for us would be in Cincinnati, Ohio. And then if there was an appeal of a court case there, like they challenged the decision at that level, then it would go to the Supreme Court in Washington, D.C. As you can see here, there are a lot of district courts, not nearly as many appeals courts, and then there's just the one, obviously, Supreme Court. And this was taken in I think this runs up to about the year 2000. So there have actually been more added at some levels. So who are the federal judges? Who are the judges that are in like the Supreme Court and then our federal courts at the circuit level and at the district level? Who are these people? How do they get their jobs? So typically, not always, but judges have either one, held previous political office, such as a prosecutor, so like an attorney for the government, or a state court judge. They worked in the state court systems. They were a judge there. So they've got some experience in terms of working in the court system or being a judge itself. Maybe they have some political experience, such as helping to run a campaign, possibly for the president or the president's party that he's, or in future she, is a part of. They have some sort of prior judicial experience of some sort. And traditionally, they've been mostly white males. Traditionally. Some have been lawyers as well. Here's just a picture of a previous, not just, I don't want to say just, important dude, Justice Scalia. Here, he passed away just a few years ago. So again, he served right up to his death. He obviously he's a white male. That's why he's the picture. Because traditionally, in the past, most of our Supreme Court justices have been white men. Now that's changing. I'll show you in a second. So how do they get chosen for their jobs? Well, the president, as we've talked about, if there's an opening, not only at the Supreme Court, but any other federal judgeship that opens up, the president gets to nominate somebody for that position. And when they nominate people for that position, they're then having to usually be checked out by the Department of Justice, senators, and oftentimes senators actually from certain states give the president suggestions like, hey, there's this rock star judge from my state. Let's say I'm from Utah. From Utah, I think you should peek at that person when the next federal judgeship opens up, and think about that. We saw that we call it senatorial courtesy. That's one of the things senators oftentimes do is suggest to the president who should fill some of these judge jobs. Also interest groups of people that push for certain judges to be named to judgeships around the country. And they oftentimes then go through the Senate Judiciary Committee as well. And then lastly, they're nominated by the president, and then they need to be confirmed by the Senate. So there's another check that when we talk about checks and balances, that the legislative branch, the Senate, as part of Congress, checks the president's power to appoint judges. So the U.S. Supreme Court, that's the one most people know about, right? At the federal level, that's the highest court in the land. Okay, what happens there is kind of the end game. There are 9 justices, but this needs to be changed. All but 7 now have been white men. Just in the last few months, that 6 has been changed to 7. Here were a bunch that were non-white men. This is actually the full list, sadly. Thurgood Marshall and Clarence Thomas were two African-American men. Clarence Thomas is still serving on the Supreme Court today. Sandra Day O'Connor, Ruth Bader Ginsburg, Elena Kagan, and Sonia Sotomayor are the four women. Now there's been a fifth. Okay, President Trump, most presidents get to maybe nominate one person to the Supreme Court, maybe two if they're lucky. Three is almost unheard of. President Trump, in just one term, got to nominate three people to the Supreme Court, and his latest was another female, Amy Coney Barrett. He just nominated. So as you'll see in a picture here in a second, the Supreme Court is finally starting to look like America, like our population does. It's not just all white men anymore. Ruth Bader Ginsburg just passed away a couple months ago. That's why Miss Barrett had the opening and was nominated then by President Trump. Elena Kagan and Sonia Sotomayor were both nominated by President Obama, so from the previous administration. Right now, the Chief Justice is John Roberts, and with all the impeachment stuff going on, now that President Trump has been impeached, if and when it then goes to trial in the Senate, he will be the judge that runs that trial. He doesn't decide guilt or innocence. That's what juries do, right? Not the judge. And in that case, the senators will be the jury. But Chief Justice John Roberts, as it's stated in the Constitution, in terms of an impeachment trial in the Senate, he's the judge that gets to kind of be in charge and run the day-to-day operations of that trial. So the U.S. Supreme Court, in 1 year, they don't have enough time, or they have limited time, right? So they have over 7,000 court cases that are requested to them to appeal, on appeal, that want them to relook at it. Well, they don't have the time to do that. So they need to choose carefully what court cases they're gonna listen to and hear and decide on. And usually they do that. There are about 100 of them every year. So a lot of their time is spent actually just figuring out which court cases of these 7,000 are we gonna listen to? Are we gonna hear? What we call it. And again, they don't even have the time to do that. So they've got people that work for each of them called clerks. And each of the 9 Supreme Court justices, that's part of the clerk's job, is to go through these 7,000 requests and kind of help guide the Supreme Court justices as to which court cases might be worth hearing. And usually they're obviously going to pick maybe what they consider the most important, or the ones that maybe involve the most amount of people in terms of who's complaining about something. Like if it's just one person complaining about a certain thing as opposed to 5 million, well, we probably want to consider the one that the 5 million people are complaining about. That's important to more people. That may have an effect on more Americans' lives. So here's a picture of the current Supreme Court. In fact, it's so current, the Supreme Court is, like there was a change made so recently that I could not find the picture. And I don't know if they haven't taken one because of COVID reasons. They don't want to sit close enough to each other. And if they did, they'd have to wear a mask and that would look kind of goofy. Or because it's just so recent, they haven't had time to take their picture all together. This is like in elementary school, you took your class picture. This is like the Supreme Court's class picture. And these are the current 9 justices on the Supreme Court. Now, due to my magic technology skills, I added Miss Barrett, her picture on her predecessor's body. This was Ruth Bader Ginsburg. She was the one that just passed away recently. And then Miss Barrett is pictured here. She's the one that was nominated by President Trump and then confirmed by the Senate. So this is the makeup. So as we said, typically in the past, it's been all, oh, my lights went out. Ah! There we go. In the past, it was typically all white men. Well, fortunately now we're seeing some change, right? So there are right now 1, 2, 3 people of color that are non-white or non-Caucasian. And Mr. Biden, our incoming president, has said that if he gets to seat somebody on the Supreme Court, there would be a good chance that 1, it would be a female, and 2, it would be a female of color, a non-white female. And so again, it's going to start to look more and more like the makeup of our actual population. I think, and I'm no expert. There's a good chance, though, in these 4 years, he might get a chance to nominate someone because this man right here has suggested that he may be retiring soon. And so that spot would be filled there. Okay. So right now we see 3 women on the Supreme Court. That's the most have ever been on the same time. Again, we see 3 minorities on the Supreme Court, which is the most we've ever had at the same time. And chances are that's going to increase. The Supreme Court decisions, the majority vote required to determine the outcome of a case. So right now, there are 9 Supreme Court justices, so is going to have at least a 5-4 vote, right? Maybe 6-3, 7-2, 8-0, 8-1, 9-0. But whatever the majority is, that's the way, however they feel about a court case, that's how the law is going to work. At the end of a court case, the Supreme Court justices write what we call opinions. So the majority, so say there's a 5-4 decision on a Supreme Court case. The majority is obviously the 5. They choose between those 5 Supreme Court justices. They pick somebody that's going to write the majority opinion. And what that is, it's basically a document that they write out and say, here is why we voted the way we did. And they choose one person to do that. You can go back and look at every single Supreme Court case in our country's history and look at the majority opinion as well as the dissenting opinion. So if there are 5 people that voted in the majority, it means there are 4 people that voted in the minority. One of those 4 justices needs to write what we call the dissenting opinion. And that states the reasons why the judge or judges disagreed with the majority opinion. And sometimes there's a third opinion that's written called the concurring opinion. And that states reasons why a judge agrees with the decision of the majority, like they were in the majority, but for different reasons. They need to explain why they voted the way they did. For example, let's say that there is a law that's passed by Congress that says students on school buses must wear seatbelts. Okay, students on school buses must wear seatbelts. Well, let's say that law gets challenged and it makes its way up to the Supreme Court. And 5 of the Supreme Court justices vote yes, we agree, it follows the Constitution. Well, the majority is the 5. The minority is the 4. 4 of them said, no, we don't like that. So the 5 will choose someone to write the majority opinion. Well, let's say the majority, like 4 of them, voted yes because their reasoning in the majority opinion would be that it's best for the health and safety of the students in case they're in like an accident. Like it makes sense, they should be in a seatbelt. Well, we still have one more person that voted with the majority, but if they voted for a different reason, so maybe one of them says, I voted yes on this, but it's because I think the kids should be in a seatbelt so that they're not all jumping around all over the place, causing distraction for the bus driver. So they voted yes, but for a different reason. So they would have to write a concurring opinion. That doesn't always happen. Oftentimes, in fact, most of the time, usually the people that vote in the majority, I'll vote that for the same reason, or they agree on the same reason. And so they don't need a concurring opinion. Of course, they don't have the power to implement their decisions, though. So they make a decision, great, but they better hope that the executive branch enforces their decision. Right? That's the job of the executive branch, enforce the laws. So as the Supreme Court decisions are made, first of all, a case on the docket, approximately 95 every year. So they figure out which 95 to 100 court cases are going to be on their docket, like that's their schedule for the year. From there, if your court case gets decided that it's going to be on the docket, then these what we call briefs are submitted to the Supreme Court justices. It's basically an overview of the court case and all that's been done with that case at the lower level courts. Now, they call it a brief. These briefs aren't brief. They're pretty thick things. Then they go to oral arguments, where the lawyers then get up and talk about the court case and why it's being appealed. From there, so the justices have all been sitting up in front at the Supreme Court. They've heard the arguments from the lawyers. They've asked them questions. Then they go back to a conference where they all meet together, the 9 Supreme Court justices, and they discuss the case. They discuss the stuff from the brief. They discuss what the oral arguments were from the lawyers. And then they take their vote and they figure it out, and then they assign who's going to write those opinions. From there, the opinions are drafted, they're put together, they're circulated to make sure that they're good, and then the opinions are announced. That final decision are made public. How do the justices vote? Again, legal factors come into play. Their judicial philosophy. Some act with judicial restraint, which means they're very strict about, hey, here's what the Constitution says, here's what it's written, this is what we're going to follow. Others are more judicially active. They see it more of like, well, the times change, meanings change from when the Constitution was written back in 1787 to the year 2021. Judicial restraint basically means it's more conservative. They don't want to have an active role in changing rules and regulations and stuff like that. Activism means they're more active. They're a little more often, I'm trying to think the best way to say it here. They're a little more in favor of changing some things, making things change. They oftentimes vote on precedent. So if the Supreme Court prior judicial decisions, precedent is a word for like standards that have been set. And sometimes they'll hear a court case and they'll be like, oh, there was a very similar court case 20 years ago. And they'll look back and say, how did the Supreme Court rule then? And if they agree with it, they'll just say, hey, we don't even need to worry about this. Like we're just going to go with the same type of ruling. Sometimes precedents change though, precedents. For example, back in 1896, there was a famous court case called Plessy v. Ferguson. And this is where there was a man with like 1/16 African-American blood in him. And he was waiting in the white area at a train station. He was told he couldn't. He had to go wait in the colored area of the train station because he wasn't fully white. He challenged that, saying we shouldn't have to sit in certain areas based on our race. The Supreme Court back in 1896 ruled that no, you know what? As long as there are separate but equal facilities, there can be segregation. There can be a white-only water fountain, and there can be a colored-only water fountain. So that's the name of the game in the United States for a long time. That was legal, as long as there was separate but equal facilities. Okay, so then we bounce ahead about 50 years, 1954. I think it's a father that files lawsuit, and again, this is one of the most famous court cases in our country's history, because his daughter, who's black, is not allowed to go to the elementary school like right down the street within walking distance because of the color of her skin. She has to go to the non-white elementary school, which is much further distance, and he doesn't think that's fair. So he files lawsuit. It makes its way to the Supreme Court, where the Supreme Court, the rules been, hey, they followed Plessy, and schools up to that point were allowed to stay segregated as long as they were separate but equal. Schools provided for both. Well, the Supreme Court then overturned a precedent in 1954, and they said that's no longer legal for schools. You can't have, well, the terminology is what they said in the opinions was it's inherently, you can't have separate but equal. Like you can try, but one's not going to be equal to the other. And so not only did that then set a precedent for not allowing segregation in schools, but that carried over to like movie theaters, restaurants, basically any public places. You can't segregate by race. Again, how do they vote? Sometimes they vote on behavioral characteristics. Personal experiences of the justices affect how they vote. early poverty, job experiences, friends, relatives, all affect how decisions are made. I mean, just think about how you view certain things and your opinions about certain situations. It's based upon your life experiences. I can look back on my life and or when I make decisions or I have opinions about certain things, I can then, if I sit back and analyze, like, why do I think that way? It's because of things that have happened in my life that have affected my life. For example, Justice Sotomayor. Okay, she grew up very poor in a single parent family in downtown New York City, in the Bronx, you know, that part of New York City. And so a lot of the decisions she makes are based on those experiences. I've read her book and her autobiography, and she talks about that. So she's going to be much more in favor of voting for or supporting laws that support people in poverty or support um, maybe rules or laws that help out minorities because she was helped out by some of those programs that supported females and supported minorities growing up, giving her the experiences to go to certain schools that she could not have gone to if there wasn't any like government assistance, which then allowed her to go to some of the top schools because she's like a whiz, top schools in the country, which then led to her eventually being on the Supreme Court. Sometimes they'll vote based on ideology. Um, so the ideological beliefs influence justices' voting patterns. So their ideas, the way they think about things. Sometimes public opinion does. Like these people are human. They see the news. They see what people are thinking about certain issues or things that are going to come up through the court system. And so sometimes, hopefully not, they can be swayed by public opinion. Hopefully they're not though. Hopefully their jobs are insulated, we say, enough because what don't they have to worry about? Like they could give two hoots. Like what happens if they make a decision that 30 million people hate? It doesn't matter. As opposed to like someone in the Senate or in the House of Representatives or the president, they need to worry about public opinion because they have to run for re-election to get their jobs. Like they can't make too many people mad about the decisions they make. We don't have that with the Supreme Court justices. They don't have to run for re-election or judges. Like they're in, whether people are happy with them or not. They can't lose their job just because of that. They can't get voted out of office. That was done on purpose. We want our judges to be able to make good, sound, rational decisions and not be swayed to do something bad just because that's what a bunch of people that are voting for them want them to do. All right, the last couple of things here. We've got two different types of court cases in courts. We've got civil court cases and we've got criminal court cases. And it's important that you know the difference for these two things. So a criminal law, that's laws that regulate public conduct and set out duties owed to society. So if you commit a crime, like that's murder, theft, robbery, right? Those are crimes that are committed. A criminal, so then you'd go to a criminal case. That criminal court determines whether a person accused of breaking the law is guilty or innocent. The prosecution, which is usually the government, is trying to find that person guilty. That's the prosecution, is going against the defendant, the person trying to defend themselves, saying, no, I'm not guilty. And to find someone guilty in a criminal court case, the term is that there needs to be guilt beyond a reasonable doubt. Beyond a reasonable doubt. Basically, if you're going to find someone guilty in a criminal case, juries are told like they've got to be basically 99% sure, if not more, if not 100% sure that that person is guilty. Okay, that's beyond a reasonable doubt to find someone guilty in a criminal case. Now, in a civil case, this is where you see like on TV, like Judge Judy. Okay, it's two people that you see on TV at least. Sometimes it's two groups or two businesses that are like in an argument over something that happened. Civil cases. Court settles a disagreement over some issue, such as a contract, a business deal, a divorce, an accident that happened, and usually like someone's suing somebody else for again breaking a contract, Or like a car accident happens, that was an accident. The person that's car gets all jacked up and they're in the hospital because of medical issues for it. Like they're suing the person at fault for usually money. We're not talking about jail time here. It's usually for money. For example, if I'm mowing my yard and then accidentally a rock shoots out of my lawnmower and smashes my neighbor's window to his house, he might sue me for the damages for that. That would, and if I don't want to pay him, if I don't cover it, and he thinks I should, he can take me to court in a civil lawsuit. Again, here we've got the plaintiff, the person doing the complaining. So in that case, that'd be my neighbor. He's complaining that he was wronged against me, defending myself, saying, heck no, I'm not paying for that. In fact, it was because of the rocks that you put in your yard that rolled into my yard. That's the one I hit. So really, in a sense, it was your own fault. That'd be my argument. To find someone like guilty or at fault in a civil law case, we say they have to, there needs to be preponderance of evidence. So yeah, it's more than likely that that person was not in the right. They were in the wrong. They did something wrong. So there it's like, maybe like we're pretty sure that that's the case. As opposed to in a criminal case, it's the reasonable doubt, like darn well sure that that person's guilty before we punish them. And why is there a difference here? Well, here we're talking about in a civil case, like the punishment being like a payment of money. Big deal? Yeah, it is, but not nearly as big a deal as what the punishment might be for being found guilty in a criminal case. Like there we're talking about sending people to prison oftentimes or to jail. Okay, that's a little bit more serious, I'd say, than spending 10 years in prison as opposed to paying $1,000 fine. So those are the differences between a civil case and a criminal case. All right, hopefully that was enough for you to fill out the notes. If I was going too fast, go back and figure those things out by looking at those things. Okay, the last thing you need to do now, posted in the classwork, is this worksheet called Judicial Branch Review. Open it up, and the directions say use the notes we just went over or any other resource that you have or need, and you need to fill these out. Do it on your own, please. Fill out these questions, answer these questions, get that turned into me by next class period, and you should be good to go. So you can use the rest of the hour now today to finish this up. If you get that done, send it in to me, and then please, 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 it's free time for you, right? FREE. Find reasonable educational entertainment. Start studying for a test you may have later in the week. Read, but please don't be a distraction the rest of the classes. They're working on this. Hey, I will be back in school on Thursday. So if you've got questions for me, need to touch base with me, I'll be there Thursday. Okay, thanks for paying attention. There's the judicial branch in a nutshell. Enjoy the rest of your day, and I will see you in a day or two. Later.